Okay. It's looking like I gotta tie this, tie up real property like tonight. Because let's just say starting Sunday. Let's make Sunday our day. Starting Sunday, we're gonna shift to another subject for next week, and we're gonna hit them a week at a time. Might double up on 1 week. So let's just pick up with chapter 3. I know my outline's stupid. Don't care. I'm respecting the law by reading all the history behind it. Limits and possibilities of real property, personal property, and intellectual property. Intellectual property, general principles of intellectual property. Property is one's ideas, patents, and expressions, copyrights. Ideas, patents, expressions, copyrights, brands, trademarks, and proprietary secrets, trade secrets. Acquisition by creation this time. Before we talked about, let's see if I can remember it, first possession through discovery, labor, capture, right? All these things that the bar doesn't care to test you on. They're neat concepts. So now we're talking about creation. Acquisition, property rights. So then there was subsequent possessions. First possession, there was discovery and capture. Was there not one more? And labor. Occupancy theory, which did involve acquiring, subdue, control, capture, kill, acquire, control, possession, not necessarily have to carry it away if it's too big. But then there was subsequent possession, and subsequent possession was involved lost property, mislaid property, the finder. I want to get this right. The finder's, I want to say title. A finder of property acquires, there's two different concepts here. Finder has right above everyone except proper owner and previous possessors. However, finder of mislaid property acquires no rights in mislaid property, is entitled to possession of lost property against everyone except the true owner, and is entitled to keep abandoned property. I like that rule from Michael versus First Chicago Corp., which is probably one of the newer cases in that whole analog. So then we talked about adverse possession, which is actually going to be on the bar, and that one's kind of hard to mess up. It's like you need to have open and notorious. The adverse possession must be open and notorious, exclusive, continuous for the statutory period. Continuous, open, and notorious, adverse to the interests of the owner of record. For the statutory period, taxes sometimes are involved, and the couple other elements to consider is tacking and tolling that can extend the statutory period. The other potential there is what is hostile, which is one adverse to the owner, but does it have to be subjective hostile, or like subjective good faith under color of title, claim of right, all those concepts. They come up with a list. What is continuous, and what is exclusive, what is open, that's such that it would put the owner of title on notice of the adverse possession. So all that's actually on the bar. Getting back to this stuff, this personal property stuff is really not on the bar, but I go in through it for fun. Acquisition by creation, property, and one's expression and ideas, the general principles presented in Case 5, which was International News versus Associated Press. News of the day is public and not copyrightable because literary value that only retains copyrightable nature while secret, or only retains the copyrightable nature as long as it's a secret. Holding was quasi property right can vest in the news between or relative to the two competitors. Information is non-rivalrous when the use of it does not interfere with the use of it by others. Information is non-excludable when it is difficult to prevent people from using it. So that's your quasi property right can vest as between those competitors. Info is non-excludable when it is difficult to prevent people from using it. There's this hot news doctrine that came out of here. It is expensive to collect news. When is it time sensitive? When defendant rides free on collected material, when free rider competes in plaintiff's market, and the relationship diminishes the incentive to collect news. So those are some obviously public policy reasons why there should be an interest in the news. Like there should be a property interest in the news, but it's there's definitely it's definitely only by a quasi property right. The factors to consider are those I just read about hot news in the hot news doctrine. So I'm just going to move on to Cheney Brothers versus Doris Silk Corporation. It's about a design, like a fashion design. Does property vest in fashion design? And if so, is it protected? The rule at common law or statute, copyright. Whenever anyone has contrived a design process, machine secret, with good right to protection, others may be forbidden to copy it. Otherwise, as here, a man's property is limited to the chattel which embody his invention. Others may imitate at their pleasure. Intellectual property law limited monopolies of protected material. That's kind of the point of it. And then in development, copyright Act of 1976 from Title 17 of the United States Code, Section 101. Test. Is there an ownership of a valid copyright, and is copying of constituents' original work? Is the copying at issue, I guess, of a constituent's original work? Copyrights are transferable. Copyrights last for life plus 70 years now as of this act. More for companies, which is between 95 and 120. For some reason, they talk about Disney, like Walt Disney Act. This has like a unofficial name that ties back to Walt Disney. It's like a Walt Disney period or something, is what they refer to that. Purpose of copyright is not to reward the laborers, but to promote the progress of science and useful arts, as I was just saying. Copyright includes literary works, music works, dramatic works, pantomimes, choreographic works, graphic sculpture, motion pictures, audiovisual sound, and architecture. Protects form and mode in which ideas are expressed, does not protect the ideas, but the expression thereof. And fixation is the tangible media involved. This includes page, CD, tattoo, hard drive. The originality requirement is also referred to as the sweat of the brow doctrine, and labor theory again comes in. The modem of creativity, compilations of pre-existing data may be copyrighted, and there's an exception in Feist. Feist might just be the phone book example. I'm not sure. Copyright is instantly accrued, meaning that it need not be registered with the Copyright Office to accrue a cause of action for copyright infringement, but must be registered before asserting rights in a lawsuit. First sale doctrine, coming up below, applies to copyright as well as patents. The next case, 7, is I just wonder why it's 7, because I thought they were I thought it was already past 15. I might have done this out of order. That happens. Holding in Smith versus Chanel Inc. is that imitators may use Chanel's trade name and profit from imitation if imitation good is not patented. Case 10, White versus Samsung Electronics America Inc. Rule: the Latham Act provides the right to publicity and false representations in ads and involves impersonation of voice, name, signature, likeness, evoke personality, appropriation of plaintiff identity. And fair use examples from White versus Samsung include short life of patents, finite life of copyrights, copyrights limit on ideas, fair use doctrine, prohibition of copywriting facts, compulsory license of TV broadcasts and music compositions, federal presumption of overbroad intellectual property laws, nominative use doctrine of trademark law, and right to make sound alike recordings. In parentheses, we're talking about parodies. Patents can be granted for processes, products that are novel, useful, and non-obvious, and not natural or physical phenomena or abstract idea. At common law, statutory rights of publicity were for 20 to 100 years and persist after the death and descend by will or intestacy, restricted by first sale doctrine, in parentheses, referring to that as exhaustion, because that would be a restraint on of trade and alienation, in quotes. Example, genetic bacterium is patentable if not found in nature. That's from Diamond versus Chakrabarty in 1980. Now, we're entering into a new section here, property in one's person. This is the dominion rights of use, control, disposition, for example, search and seizures, medical consent, and rights to a dead body or body parts. Moore versus the Regents of UCal in 1990. This hairy cell leukemia from spleen was removed and used to develop a patent, but the patient was not made aware of the usage of his body parts and brought a cause of action for a lot of different things. He was like not just treated and left, like he actually was told to come back, and some of that was misrepresentation to have him come back for like routines that really was just to develop this patent. So the cause of action was for intentional infliction of emotional distress, breach of fiduciary duty, and informed consent, negligence, misrepresentation, fraud, and deceit, but conversion. All of those were reversed, citing the Uniform Anatomical Gift Act and National Organ Transplant Act, making it unlawful for any person to knowingly acquire, receive, or otherwise transfer any human organ for valuable consideration for use in human transplantation if the transfer affects interstate commerce. Copyright protects the expression of ideas, books, music, art, but not the idea until put in tangible media. Need to be novel like patents. Copyright protection is 70 years after the death of the artist, author, creator. Feist Publications versus Rural Telephone Company. The telephone directory consists of facts that are not copyrightable. The compilation is also not protected because there is no creativity involved. Trademarks. Words or symbols indicating the source of a product or services. Trademarks protect product owners if use of a similar mark would confuse customers. Trademark protection subsists as long as the owners use it. Abandonment, loss of trademark. The trademark doesn't become generic, and the trademark is defended by product owners. Trade Secrets Law, Federal Defend Trade Secrets Act of 2016, unlawful appropriation, hacking, convincing employees to breach a duty of confidentiality, infringement. This is all part of the trademarks section, I think, unless it's a new section. So trade secrets, there's a law about unlawful appropriation by hacking or convincing employees to breach their duty. Okay, and infringement is so an ownership of a valid copyright in the work and defendant's conduct, actual opportunity to copy or access, and an original work and allegedly infringing work share enough unique features to give rise to a breach of the duty not to copyright the original. Those are probably elements. So you need a valid copyright and the defendant conduct. I don't have more surrounding the defendant's the contours of what we're looking for in defendant conduct, but an actual opportunity to copy, i.e. access, and the original work, and allegedly infringing work share enough unique features to give rise to a breach of duty not to copy the original. Copyright estoppel. If a copyright holder presents false information as factual, it cannot then turn around and sue the infringement, asserting that the false information is copyrightable because of the factual character. Then you have the public domain and the public trust doctrine. So, what's copyright estoppel again? I mean, obviously it's a defense when you're being sued for copyright infringement, but the copyright holder presents false information as factual, it cannot then turn around and sue for infringement, asserting that the false information is copyrightable because of its non-factual character. Matthew versus Bayhead Improvement Association. Rule: the public trust doctrine guarantees public access to municipality-owned dry sand areas as well as the foreshore. Copyrights public domain. Elred versus Ashcroft. Trademark laws public domain. Origin Potter's mark. Latham Act. Enacted in Congress, treats generic terms as part of the public domain and categorizes marks into descriptive. That's the only category I have written here for within the trademark laws. So you've got another case, Authors Guild versus Google Inc. The fair use of a copyrighted work for purposes such as criticism, comment, news reporting, teaching, including multiple copies for classroom work, scholarship, or research is not an infringement of a copyright. Analysis. Factors include purpose and character, no competition, no commercial motivations, nature of copyrighted work, amount and substantiality of the portion used in relation of the copyrighted work as a whole, and the effect on the market. So, like, this case is the reason why Google can, like, show, like, one page of a book, but not the whole book, basically. Case in re Cordua Restaurant Inc. Generic terms are not registerable, and a registered trademark may be canceled at any time on the grounds that it has become generic. Doctrine of foreign equivalence and making generic terms plural have no effect on genus. That is a fancy way of saying the same thing I just said. Analysis. Would public use of the mark be understood by the public to be genus, which is another word for generic? I have A, B, H, I, and J. A, what ownership entails the rights to exclude, alienate, abandon, and destroy. The right to exclude and its limitations, the right to transfer and restraints on alienation, property bundle of rights, and we begin talking about the right to alienate, which was limited by excessive restraint in Doris versus Doris. The language of a deed overly controlled their mother's use of the property so that she cannot rent it or sell it and is forced to live there. There is too restrictive application of the right to alienate. Unlimited restraint against alienability is per se invalid and unreasonable. So we have now shifted, even though it's not apparent in my outline structure, but we've gone into the bundle of rights. You own something. What are your rights? The right to alienate means that you can sell it or give it away. That's your right. As it with respect to the property. So along with that, there's also, you have to balance that with the right of a free market and society. And so if you unduly limit the marketability and saleability of some precious commodity, then, or with respect to the person's right to alienate, then excessive restraint of a party's right to sell something or hold something as opposed to selling something is really, really the concern. I explained that well. I mean, there's two interests. There's the person who owns it. They're restricted from selling it as they please. And that right is being diminished. And you have to balance that against like the public's right to a market that includes things that ought to be sold in it. So the right of the public to have the ability to purchase things. Another right would be the right to exclude. So you own something to the exclusion of others. Blackstone is one of the English writers that describes some of these legal principles. And the right of property that is the sole and despotic dominion which one man claims and exercises over the external things of the world in total exclusion of the right of any other individual in the universe, is how this has been described in the past. However, every person's right to the exclusive enjoyment of his own property for any purpose which does not invade the rights of another person. So again, there's finding the balance between total exclusion. You cannot do so if it invades the rights of others, to the extent that it meets improper invasion. Right to exclude allows resources to go to the highest and best users. So that's the interest, obviously, of the public. Jack versus Steenberg Homes. Were we in the book? We'd already be on page 200. I'm skipping that. 207, there was State versus Shack. Migrants living on farming land were entitled to visitors from social services. The rule is that every person's right to the exclusive enjoyment of his own property for any purpose which does not invade the rights of another person. So that's the perfect example of when the right of exclusion invades the rights of others. These migrants living on the land cannot be excluded from activists, social service activists. Now, the right to bar access to governmental services available to migrant workers, and hence there was no trespass within the meaning of the penal statute. Title to real property cannot, obviously, the owner of the land was trying to accuse these social service workers of or governmental, bringing governmental service like pamphlets or something to migrants living on the land as trespassers. And they failed to make that argument. Title to real property cannot include dominion over the destiny of persons the owner permits to come upon the premises. And lastly, third, power to contract away what is deemed essential to their health, welfare, or dignity. And so that's like the case that explains the law best. State versus Shack. Impression Products Inc. versus Lexmark International Inc. A patent for a period of 20 years to exclude others from making, using, offering for sale, or selling its invention throughout the U.S. or importing the invention into the U.S. reads as follows. Use without authority is patent infringement, period. According to Title 35 of the United States Code, Section 154A. Upon sale of product, the patentee can no longer protect the item from resale due to exhaustion. Exhaustion doctrine limits the right to exclude. And then leave it at that and go into the right to abandon. So we had alienate, exclude, abandon. Yeah, this becomes a bundle of rights. Destroy. But first, abandon. Unilateral relinquishment. Feudal time. Land cannot be abandoned, obligated to perform services to the Lord. May prevent owner from right to destroy, deplete, consensual, bilateral transfers shouldn't be called adverse possession. Intellectual property abandonment discussed under the Lanham Act. When marked not to resume such use, and 3 years to establish prima facie abandonment is kind of how the Lanham Act operates. Proper name, birth name is not for commercial purpose and cannot be abandoned. So the first case on point is Hawkins versus Mahoney. A prisoner breaks out of prison and his belongings are boxed away. Rule: abandon property if is no man's property until reduced to possession with intent to acquire title. Pocono versus Mackenzie. Lot owners can't sell land in development because of unsuitable sewage, and the abandoned property rule was applied. to which an owner has voluntarily relinquished all rights, title, claim, and possession with the intention of terminating his ownership, but without vesting it in any other person with the intention of not reclaiming further possession or resuming ownership, possession, or enjoyment. That's how abandoned property was referred to when you're talking real property, I think, because they're lot owners. So, whatever. Right to destroy. Ironman versus Mercantile Trust Company. The executor wanted to raise the descendants' property according to her will, but was stopped from doing so by an injunction of trustees for private nuisance, encroachment, trespass, and injury. So the owner of a property had a will that their house in like a really nice neighborhood was to be raised, i.e., destroyed. And how they ruled according to the restatement second trust of section 124 is, although a person may deal capriciously with his own property, this is again the right to destroy, his self-interest ordinarily will restrain him from doing so. And if the executive carrying out the will has no interest in the real property, I don't know what the rest of that sentence was supposed to say, but what is the ultimate outcome? Where does it apply? Generally, a person has a right to destroy anything in their life, right? And their self-interest ordinarily will restrain them from doing so. So then after their death, generally, their property can be distributed the way that they so intended. However, this self-interest no longer exists anymore because they have passed on. And so to act capriciously with your property at that point, no longer restrained by self-interest, is like tends to be unfair to the public. So the public, I believe, here was able to intervene. Go to Inri Estate of Kievernagel, where the probate court rules against a widow's recovery of her deceased husband's sperm in a manner contradictory to his permissions expressed in a contract between himself and the NorCal Fertility Medical Center, which she contests with evidence, and the decedent's parents. The Probate Code, Section 1162.3, calls for recovery of asset of no financial value of immense sentimental value. Probate Code found not to be applicable to spouse as it is to deceased children and looked to Uniform Anatomical Gift Act and precedent cases, i.e. the Davis test that balances the request when preferences were not expressed by progenitors and decide to take the avoidance position. So gametic material is distinguishable from gifts. I'm not going to explain that any further. The System of Estates, Part 2. Ownership consists of an estate and an interest. A has a type of interest in a name of estate. And those are blanks, right? Fill in the blank. A has a type of interest in a name of the estate. Estate describes when the holder's possessory interest ends. Estate is a status per feudal origin. Estate is created by grant. Interest, however, describes when the holder's possessory interest begins, may be present or future. Present possessory right may begin at the time of the grant. Future possessory right may begin after the time of the grant. Freehold, normal tenures, non-freehold, leases, present interest, future interest. Right to concurrent ownership, co-ownership, co-tenancy. I'm just listing out probably sections that were written in the book. Maybe even in the introduction to the System of Estates. What these are types of estates. And then you're talking types of interests. You got freehold estates, and non-freehold estates. Non-freehold or leases. Freehold or normal tenures. But you know what the opposite of leases are, so that's how you can define freeholds. Interests, they can be present, they can be future, they can be concurrent, which involves co-ownership and co-tenancy. The taxonomy is archaic, but still used to classify these either estates or interests. Now, I want to say Cardozo, but it says Gardozo. The nature of the judicial process, 1921, restraints upon alienation, suspension of absolute ownership, contingency remainders, executory devices, private trusts, trust for charities. That all comes from probably an article called The Nature of the Judicial Process. And Riley talks about all those things. That's why I have them listed here. But I just realized the bundle of rights totally ended early. Because you had a right to, like, enjoyment, quiet enjoyment, and I didn't get into that. And there's probably even more than just alienate, exclude, abandon, destroy, quiet enjoyment. 1, 2, 3, 4, 5. That's 5. I feel like there's 7, but I don't know why I feel like that there's 7. I just do. Did I say exclude? Yeah. So we're about to enter into like the awful part of we're about to enter into all the feudal history of possessory estates, modern relevance of estates, inter vivos versus donatio mortem, I think. So I just had a definition of this recently. Deeds it's fine. Deeds, issues, other legal instruments, restatement third of property wills or other donative transfers, historical origins of the estate system. There's the Norman conquest of 1066, William the Conqueror, Roman, French, tenure, hierarchy. All tenements belong to the king, to parcel, to subservient in a manner called subinfeudation, grant to a lesser estate, and the order of which is king, William, tenant in chief, priest, knight, mesne, lord, intermediate, tenant in demesne, possessory use, session. And session comes back in, that word comes back into play. Most of these other words don't. The above list is a prioritized order of title, and as recorded in the, quote, Doomsday Book, subletting to lesser tenants was also recorded in the Doomsday Book. Fee simple estate never ends. So here we are in future interests. We just went through future interests recently. It's followed by trusts, just like it was in the earlier outline. Marketability doctrine, rule against perpetuities. So all this I'm going to read about next. And once we're done with that part, we'll be reading about co-ownership and marital interest, which is your co-tenancy. And I don't really okay, and then leasehold, landlord, tenant. So it's actually exactly the same as, I think, the order of the outline before. And that will conclude what I outlined in the first semester of real property. I want to do that relatively soon after a dinner break because the spring semester is really thick and I don't really know why. Okay. Is there something attached to it? It looks like I attached the takings clause to the back, which is a constitutional principle. Maybe even zoning. So it also looks like perhaps at the end of my outline. I entered some other some additional zoning details. Yeah, so zoning and takings are here from constitutional at the end of the second semester outline. Transfers of land, chapter 8 is where we will begin with second semester. There's the deed. This was all very similar to the Barbary outline, actually. So we kind of went over the stuff that wouldn't be on the bar. And yeah, here's easements. These are non-possessory interests. We'll go through easements, equitable servitudes, and yeah, by the time I get through all this, it's kind of double spaced, so it's not quite so bad. By the time I get through all this over to zoning and taking, like, we'll be ready to call it quits on real property for sure. Like, there's no way that when I did well on the bar and real property that we need to keep on studying this.